proceeding a matter of Mackie Motors Ltd. RCI Financial Services Ltd.
Good morning, my lord.
Good morning.
My ladies.
Just give me 2 seconds to... Yes.
My lords, I appear on this appeal together with Thomas Palsey for the appellant Mackie Motors Ltd. My learned friend David Peters appears for Credit International Financial Services Ltd, sometimes referred to as RCI. This is an appeal brought with the permission of Lord Justice Nugee against the order of Mr. Gleeson, sitting as a Deputy High Court Judge dated 22nd July, whereby he dismissed Mackie Motors' application to amend its pleading and therefore struck out its action against Renault Credit International. In terms of housekeeping, my lords, my learned friend and I have agreed to split the time equally and to take the respondent's notice in the course of my opening of the appeal. So any points on the respondent's notice I'll take when discussing the grounds, because they naturally fall in that way. And I intend to speak till about 20 to 1. My learned friend will take over, then I'll have a reply from about 4 o'clock.
I don't think you will, because we've got to rise at 4 o'clock, so you're going to have to abbreviate things a bit.
I'm obliged, okay, so we'll have to adjust to meet that.
So aim for 12:30.
I'm obliged, my lord. The claim arises in the following way. Mackie Motors had a business that was operating successfully at 2 sites in North East Scotland, Arbroath and Brechin, for the sale of new and nearly new Renault and Nissan and Dacia.
I'm sure we need all that, Mr.
You read all that and you read the background.
I'm afraid we've read the papers.
I'm obliged, my lord.
But what we do need to know is when this contract was made and why there was intentions to create legal relations.
My lord, yes.
And how you fit into the authorities, which are pretty clear.
My lord, of course. But before we get to that, and obviously I'll get to that pretty quickly, in terms of the way events happened, which puts those legal points in context, if one goes to the easy way to get it is the chronology, which is the core bundle tab 9.
I mean, when is this contract made? What's the date on which the contract is to be implied for the first time?
It is to be implied, my lord, if one looks the way we've pleaded this.
Well, I've looked very carefully at the way it's pleaded, and I'm not sure I get much of an answer. Let's look again.
My lord, yes. If you go to paragraph 31, this is supplemental bundle tab 1. There are 2 dates. The relevant date, really, 1976, alternatively, 2008. One gets that in the second half of paragraph 31.
No later. That's not a date.
But, my lord,
so what I'm interested in is what is the material that supports the inevitable inference that there must have been a contractual explanation for what was going on, rather than a non-contractual explanation.
Well, my lord, what happened is over time, RCI, which is referred to as the funder, became much more than that and started providing the capital S services. In particular, the customer financial services, the platform services, which are the services which allowed Mackie to purchase vehicles, to purchase parts, and to run the business. Also, the database services. That is a database of all the existing financial PCP and HP contracts.
I mean, I get all that, Mr. Cavender, but what I'm struggling for is that let's assume that there's a ongoing, lengthy relationship governed by a panoply of contracts, right? And as technology and the world develops, the Renault writes to Mackie on day, in 1990 and says, look, we're going to now do parts through a website. And then they write 10 years later and they say, we've got a new website now and you'll be able to order your parts online in this way. And when you've got a problem with finding a new car, you go on this website, which is the dealer section of the website, and you order your car that way, and they say fine, and off they go. And things change imperceptibly as technology changes.
No, yes.
Right. That seems to be what happened.
Indeed.
Right. Now, why is that? Well, when does that go from being something that's provided pursuant to the structure of Byzantine dealership agreements and become a separate overarching umbrella contract without anybody ever saying to each other, of course, we've got a separate overarching umbrella contract?
Lord, there are 2 points that need to be separated in my Lord's question. The first is, are the extra services, call it that, contractual? Because that was the point the judge dealt with. That's the first point. Is there any contract, or are they merely gratuitous? And that's ground one of the appeal.
They may not be gratuitous. They may be simply ancillary.
They may be ancillary, but the question is, are they contractual in the sense that can they be removed at will? Now, my answer is, as soon as they become a necessary part of providing and fulfilling the dealer agreement, and they did. So in my Lord's example, it wasn't you just could, if you like, order parts on the internet. It was the only way you could order parts. It's the only way you could order vehicles. In relation to the database services, it wasn't a nice to have. The only way you could operate the PCP and the HP offerings was through the database services.
So why have you not taken us in your pleading to the document that says, Dear Mackie, as of the 1st of January, you will need to order all parts online, and if not, you can't have any. Brackets, this must constitute a variation to our contractual arrangements.
Well, my Lord, I can go to the pleading and show you where we do plead the services as contractual. But can I answer your first question, which is...
No, but the point is, there must be some nitty-gritty. I mean, in all the cases, there is some nitty-gritty. What Mr. Peters complains about here is that you haven't made any attempt to identify the nitty-gritty. And if you could, for all I know, you might have a case. I haven't read 10 files or 500 files of correspondence. Maybe you have.
Well, my Lord, part of the problem is the other point I'll come to, we don't have all the documents. We were locked out of the system in November 21, and expressly we don't have all the documents, because there are contracts referring to other contracts we do not have.
Well, this is not a case where you say, I can't plead my case now, but I would be if I had discovery. I mean, if that would be fine, but it's not what
my Lord, we did say to the judge that we didn't have all the documents, and so, and on the authorities, that's one of the things you have regard to when deciding how far to go on a strike out of this type. And my Lord, if I can answer your first question, I said it's 2 parts. I answered one, saying it's contractual. Dealing with the second part with this umbrella. Now, this umbrella contract is almost a term of art. What it seeks to do is to reflect the reality that assume these other contracts are separate. So we have the dealer finance, i.e. the 6 contracts, we have those. The customer finance, there's no single written agreement for that. The platform services, there's no written agreement for that. The database services, there's no written agreement for that. Now, there is a written clearing services agreement. Now, you could, if by way of analysis, say they are all to be treated separately. The reality is they are all part and parcel of a relationship between Renault, the dealer, RCI, which is effectively its accounts department, and Mackie Motors. So an analysis that treats each of those services as subject to a separate contract doesn't reflect the reality. and it doesn't get you anywhere close to saying this is a relational contract. I looked at it as a whole. It's a long-term contract that requires a high degree of cooperation between the parties. So the umbrella is a term of art to reflect that reality, rather than seeing these as individual separate contracts. So otherwise, my lord, I'd have to try and imply into the contract for data services or for platform services an implied term of fair dealing. I couldn't do that in and of itself. If it's part of an umbrella agreement, which itself reflects the long-term nature of the contract, then there's an argument, an intelligible argument that you can. So, Lord, that's where the umbrella agreement comes in. So it's a two-stage approach. Firstly, are these extra services, which in my case are necessary to run this business? They're not nice to have, they're absolutely essential. They are, once the services are turned off, the lifeblood of the agreement is gone. Mackie Motors can no longer fulfil its contractual obligations under the dealer agreement. So that's for stage one in the argument. Stage two is to say, well, standing back from this, looking at these separate, on this analysis, legally binding agreements, what's the interrelationship between them? And that's where the umbrella agreement comes in. It gives the relationship between.
So what's the second part again?
The second part, my lord, is to give effect. Once you accept on this argument that the extra services which aren't subject to written contract are contractual. The question then is to put them, those services, in their proper place along all the other services that are also being supplied in parallel. And put them in the context, the judge held, and he was right, that all these services are exclusively and necessarily related to the dealer agreement.
Where did he hold that?
Paragraph 45, my lord, page 100, referring to my argument on construction. He also argued correctly that the RCI contracts exist in the context of the dealership agreement and exist exclusively for the purpose of sustaining arrangements put in place under the dealership agreements.
Sorry.
So, my lord,
he also argues correctly the RCI contracts exist in the context, exist exclusively for the purpose of sustaining the arrangements.
He's talking now, I think, about the dealer financing in particular.
Yeah, he's not talking about what you call the services.
Well, they are part of the services that we call, but he's not there specifically talking, no, about the platform and the database services. Why? Because he held that they weren't even contractual, that they were a nice to have and equally could have been provided simply out of Renault's good or RCI's good heart in order to sell more vehicles. Now that
just help me, why does essential as opposed to nice to have make them contractual?
Well, my lord, put it this way. If they're not, then Mackie Motors is putting itself completely at the behest of a third party and exposing itself to not being able to fulfill its obligations to Renault under the dealer agreement. And I'll take you through the dealer agreement.
Isn't that the way dealer agreements have operated for hundreds of years?
In what sense, my lord?
Well, I mean, they are all one-sided, because when life begins, the dealer has often no track record, and the dealer can't sell Renault cars without an agreement with Renault, so Renault holds all the cars.
But, my lord, that's certainly true.
The dealers are all the dealership agreements I've ever seen, and believe me, I've seen quite a lot in the last 50 years, are very one-sided.
My lord, that's true. But that presupposes that there is some degree of alignment between the the services that are being provided and the obligation being undertaken in the dealer agreement. I mean, here, let's give you an example. There are minimum order, annual order requirements in the dealer agreement. And they are based on a whole range of factors, including the vehicles sold in the prior year. There's a deeming provision. So whether or not you want to order them, you are deemed to have ordered and have to pay for a number of vehicles. There's a provision in the dealer agreement we can go to, which contractually obliges Mackie Motors to provide RCI finance.
Clause 10.
Exactly.
To offer it to purchasers.
Exactly.
Mm-hmm.
Which is necessarily pregnant with the notion that it is going to get that finance from RCI under the dealer finance agreement, contract 3. There's obligations in there to there's obligations in there to sell parts and provide maintenance. You can only get parts and provide maintenance if you have access to the platform services. That's the only way you're going to get parts, and that's the way you order vehicles.
So why don't you say there is an implied obligation to supply parts during the currency of this agreement? You were in breach of that implied obligation to supply parts because you cut off our access to the only way we could get them, which was the website, which you couldn't do without giving 2 years' notice.
My Lord, that is the effect of the pleading in my submission.
Well, it's not what you say.
It's not what you've pleaded.
Well, let's look at what I do plead then, so we can. If we go to the pleading at para.
I mean, you just to button it down. I can understand, devoid of the documents, that even if you have an obligation to maintain vehicles and mend them and supply parts, even if there is nothing in the dealership agreement that says they have to supply you with the parts, it could be argued, let's put it no higher than that, I mean, I'm not looking at any document, it could be argued that there's an implied obligation to supply you with parts to do that, right? Now, let's look at your pleading.
So
Which paragraph?
we start with, on this point, I think, having set out the various contracts at paragraph 21-22, dealer financing services, and the various other contractual documents at 24, the annual offer letters. In 26, we set out the custom financing services. 27, we set out the clearing services, the platform services, and the database services. So we set out that is what was consistently habitually provided to Mackie Motors in connection with the dealer agreement. And that is the premises to then para 30.
What's missing is the statement that those services were essential for the purposes of being able to operate the dealership agreement. And speaking for myself, I would have thought that that was a fairly obvious thing to plead.
Milady, yes, I take that point. If we go
Because
through...
then you've actually got something that resembles, as my lord says, a case. Because you've actually got the premise upon which you can say there's got to be some implied term that they will continue, they won't turn off the tap in terms of providing you with these things, because they know that you can't then fulfil your contractual obligations to others or to them without it.
My lady, yes. That's certainly the intention of the plea, and certainly in argument before the judge. That was the way it was put, and the premise on which it was put, that they were necessary. And his answer to that was, well, they may be nice to have and may increase the sale of cars, but he didn't accept that they were necessary. So
where does he say that?
That says that, my lord.
Sorry? I don't recall the expression "nice to have."
No, that's my summary. So it's para 20.
Yes, para 20 is critical, isn't it?
It says, Mr. Cavender argues there are other services also provided which fall outside the framework of existing, and vision of these services necessarily implies the existence of some legal arrangement in respect of them.
Yes, but necessarily implies the existence of a legal arrangement. It's different from these services were necessary in order to operate the existing legal arrangements, which is what you should have pleaded, and which would have actually made some sense.
Well, my lady, yes, I mean, I take that point. I can check whether there are any other paragraphs I can refer you to. But certainly the evidence before the court was they were necessary.
Yes, but you see, it's not for the judge to make out your case for you with respect, Mr. Cavender. The judge can only do the best he can with the material that he's given. The material he's given is not a case saying we needed to have these services in order to be able to operate the relationship. I suspect if he'd had that material before him, he might have reached a slightly different conclusion in paragraph 20.
Well, my lady, certainly the evidence he did have and was taken to in the evidence of Mr. Mackie is these services are necessary. And I took him to that. Perhaps I can remind you of that. And his answer was that they were not. So if you go to Mackie 1, this is supplemental bundle tab 5.
Page?
Page 53, my lord.
Is that the bundle page?
It is, my lord, yes.
Paragraph?
It starts at paragraph 55, talking about the sales channels and the systems to allow things to happen. 58, for instance, operate a system called FIST, is one of the database services. System's indispensable tool where the finance agreements for each year are stored on the system, and it outlines what they include.
I mean, saying it's indispensable is fine. I get all that. But you need to be able to support an implied, I would have thought, an implied term to the contract, at the very least. And to do that, you have, as my lady keeps on saying, that this contract, that is the dealership and the finance arrangements, cannot work without there being an obligation on Renault to supply parts or a website or, I don't know, what, database. I mean, I'm not in this business. Your clients were. They need to identify what it is without which the agreement cannot operate, and then meet the very high hurdle of showing an arguable case for an implication of a term. The trouble with the umbrella contract is that without some possible foundational structure, it sounds nice, seems very sensible, but it doesn't seem to be what happened. And contracts are about what happened.
Well, yes. I mean, going back to my lady's point about the pleading, if you go to paragraph 32, sub 2, this is page 12. This is where I jumped off going to the documents. So in the premises, umbrella agreement, pursuant to which, 1, and then 2, MBL received the service to enable it to perform its obligations and exercise its rights under the dealership agreements.
Sorry, I'm not.
So it's
paragraph. Which
30 sub 2, my lord.
in the pleading?
In the pleading, my lord, yes.
Sorry.
page 12. To enable it, I mean, that could have said which were necessary to enable it, and I accept that would have been.
I think it would have to be essential, wouldn't it? Trouble with all of that is that now that you've reminded me very helpfully of Mr. Mackie's witness statement, he doesn't go that far. Mr. Mackie's witness statement, in the passage that you've just taken us to, has said, without access to RCI's systems, I believe we would not be competitive. Well, the fact that it's going to cause the dealership a degree of problems with their own competitive structure is one thing. Saying we can't actually provide the services to our customers that we've promised them and that we are contractually obliged to provide them is a different thing. And he doesn't go that far.
Yeah, my lord, if you go to Mackie 4, my lady, there's further evidence on this, where he outlines about the cessation of business and what happens as a result of being shut out from the system.
That's tab 7 page, please.
92. 92, my lady.
Yes.
Where's 68, my lady?
Yes. Yeah, well, that's more like it.
Is indispensable to the operations of the dealership.
Sorry, I need the paragraph again.
68.
68, my lord, page 92 in the bundle.
Thank you.
Yeah, that's much closer.
And then paragraph 72 to like effect.
Well,
72.
My lady, yes.
I mean, it is closer to it, but online systems have become critical to the operation.
Paragraph 80, my lord, just to interrupt, is
80.
80 shows the effect of that when shut out of those systems, what the effect was, which again supports the necessity of those services in order to operate the business.
Right, just it says no business could be conducted.
Correct.
What was the answer to that?
What was what, my lord?
What, was there an answer to that? I suppose there's no answer to anything.
There's no evidence put in by...
Nothing on the other side.
No, no.
Okay.
So whilst you can criticise the pleading in 32 for saying enable rather than indispensable, certainly the way that the thing was put in front of the judge in terms of argument and evidence, these were absolutely necessary and indispensable, and therefore contractual.
But it's a leap to say that they're necessary services and therefore contractual.
My lord, it is. It's an inference, as it was in Heiss when you gave judgment there, in that case, and we'll go to that.
Yeah, but Heiss is a very different case, because Heiss, there was an apprehension right from the beginning that what was going on was going to be contractual, and the lawyers didn't complete the agreement. I mean, you know, it was a hotly contested argument in Heiss.
The other thing about Heiss, my lord, remember, of course, you're talking there about a group, a holding company and two wholly owned subsidiaries, where you might say, well, maybe it doesn't need to be contractual because it all comes out, we're all owned by the same person. That doesn't apply here. Mackie Motors is obviously an independent company. There's no reason for it to take on trust the very lifeblood of its business and the very lifeblood of its business to perform the dealer agreement it had signed and had run a business for 50 years on. So when you ask the question, and in my submission the judge went wrong here and actually deciding whether it was necessary or not, of course that's the test. In all the circumstances, in regard to conduct after the alleged time of the agreement as well as at the time of it, is whether there is an intelligible argument that that is so.
What's the position if the umbrella agreement is really a figment, perhaps, I don't want to sound rude, but a figment of legal imagination? But there is a case for the implication of some hitherto unpleaded terms into either the finance agreements or the dealership agreements, where does that leave this appeal?
Well, if, my lord, you thought that was possible, I mean, as a matter of pleading, is pleaded very widely. The umbrella agreement, you could say, well, we accept there were contractual services, but you're not necessarily satisfied that all the services fitted under the umbrella, or necessarily it was a tripartite arrangement. But we've still pleaded the services are contractual. The court could reach a conclusion. It doesn't fully accept that pleading.
Well, I mean, it's really almost a different case from that. It's not really that the services were contractual, because it's really some kind of estoppel or representation case, or some kind of estoppel by conduct that you wouldn't withdraw these services and make it impossible for Mackie to perform its side of the dealership arrangements without giving reasonable notice. I mean, there's lots of possible ways of framing it.
Lord, yes.
The problem is you put all your money on this umbrella agreement, which is neat, but unsupported.
But, my lord, as you'll see from the judgment, I also argue before the judge. You may think it's not pleaded.
So?
There was an estoppel argument, was there?
There is an estoppel argument, my lord, yes. That is wrong.
But it's not appealed.
Yeah.
Is it?
It is, my lord.
It
Oh,
is.
sorry.
Yeah.
Sorry.
So that is in play. And you have to bear in mind here, we're at a really early stage, so although we're not allowed a mini trial, my learned friend has to put a defence in. He can say, oh, well, maybe this estoppel doesn't quite work for this reason, in which case...
Well, I mean, it's a very good reason, because estoppel doesn't found a cause of action.
Well, no, but my lord, here, without jumping to that, all we're saying is it stops the reliance on the 7-day notice. That doesn't provide the cause of action. There is either breach of the dealer agreement and or of the so-called umbrella agreement. You're not relying upon the estoppel to give you a cause of action.
I mean, the difficulty I see with this case is that I can see, it reminds me, you'll forgive me for me saying, or maybe you won't forgive me, maybe I better not say it, but it reminds me of a case that, obviously you've got a complaint. Your clients are cross with a reason. But unfortunately, we have to be confined, particularly in this court, to cases that are pleaded and thought through, because otherwise they have no chance of answering it. So it becomes like a game of whack-a-mole, where, it pops up here and you bang it down and then we don't know what the case is about. And, I take it back about the estoppel, the promissory estoppel, but I'm not sure that by itself gets you home. What you need to do is to go, what I feel you need to do is to go back to square one and say, what is, when this contract was made, and if not when the contract was made, when an essential service like the supply of parts online or the database or whatever it is became essential, there arose, by conduct, by something else, an implied term. And here are all the particulars. Because what Mr. Peters says, and I tell you right away, it appealed to me when I read it, is I don't know what I've got to deal with here. I don't know when it was happened, I don't know why it happened, and you haven't addressed the question of how this contract came into being.
Well, my lord, if I can reply to that, we did also argue before the judge, you may say it's not covered by the pleading, that the implied term should be implied into, separately, ignore the umbrella agreement, into the RCI contracts. And he considers that and dismisses it as an idea. What the court has to bear in mind here, one's doing two things. The services, to some extent, are a distraction here. Because what Mackie Motors has to show is really two things in order to get a claim off the ground for damages. It has to show it needed both services, the services we've been talking about, and it needed the dealer finance. He needed both of those things. And the conclusion of the judge was, firstly, that the services were not contractual, and that's what we've been talking about so far. That's ground one. Secondly, he found that the financing contracts were such that at RCI's whim, they could reduce the credit to zero.
That's the discretion points.
That's the unfettered discretion point. So whatever the position with the services, the funding, even ignoring the 7-day term, even during the currency of the RCI funding agreements, they could reduce the funding to zero.
So you would get, even if you could get an implied term about parts going,
Yes,
you'd never get any damages.
correct. And also the funding is also for the parts.
Yeah.
So it's all part of the same story.
No, but I mean, even if you could get a very simple implied term that says you can't cut me off from ordering parts for my customers without giving notice because you've agreed to, because I've got an obligation to supply parts, and
Yes.
it's a collateral obligation.
Yeah.
But even if you could get that off the ground,
Yeah.
they said there's no point in pleading that because we can just tell you can't have any more money.
Exactly. So that's the real point. The services were an adjunct to that, which
So what's your answer to that?
our answer to that
I mean, you entered into a contract where, on its face, that was the arrangement.
well, there are two answers, my lord, and that perhaps explains why we wanted to create the umbrella contract. The umbrella contract takes that contract number 3, which is the classic example of it, from its own position into a relationship with all the other contracts, including the dealer agreement. That dealer agreement has a 2-year termination provision in it. And it's a long-term agreement and intended to be so. As such, it meets many of the criteria for what's called a relational contract in the Yang Sem sense. I see your lordship smiling. You may not be a fan of that principle, but
No, and it's not for me to be a fan of legal principles. They either are applicable or not.
But if it is, there's a good faith, fair dealing, an argument at the very least, which could then provide a constraint or restraint on someone that says, although I've provided you with funding for all this period, although there are other contractual documents that deal with credit and funding, and I'll take you to those, nonetheless, I can, without notice, reduce this to zero, and there's nothing you can do about it. Our argument is the good faith, fair dealing term could arguably have a restraint on that. So that's the first answer. The second is that...
How could a good faith fair dealing obligation cut across the express terms of the contract and provide a positive obligation to continue to provide funding in circumstances where there is no such obligation? I wrestle with that as a proposition.
Milady, yes, but that is the proposition. I accept it's
Ambitious?
it's difficult, but let me take you to the other documents before you, because my learned friend likes to look at contract 3, which is as if it sits on its own and nothing else happened since. It was entered into 10 years previously, and a practice and other, we say, contractual documents arose around it, which speak to that obligation and amend that obligation, or at least take it away from its clean words my learned friend relies on. So I said there were two answers, that's one. And the other is of a similar type, is the Braganza duty, looking at it in effect as a discretion. And how, if you have for years and years, on a stated basis, provided credit and have what are called RCI credit terms, and you have a system of yearly authorizations, which they did, and ratings, that does create a contractual expectation that you will follow that, because that's your system you've imposed and used by both parties, and you can't just rip it up.
Without good reason.
Yes.
I mean, that's not quite what Braganza said,
But it's been applied more widely than the you may not be a fan of that either, but certainly,
not
remember
for
this
me
stage...
to be a fan of decisions.
this stage, my lord, is an intelligible argument that there was a constraint. If there was no constraint, then obviously there's no case. If they can just withdraw finance and just say,
But even you, Mr. Cavender, must see that if you enter into a contract that says they can withdraw finance at will, that there must be quite a strong case for saying they can, for commercial certainty's purpose, if nothing else.
my lord, yes. If it is vanilla as that, and there's no surrounding circumstances and practice, which, together with a legal term, can create a constraint on it.
I mean, you entered into this arrangement 3 times, didn't you? Where you signed a document that said exactly the same thing 3 times.
Yes, the contracts 1, 3, and 4 contain the same terms, my lord, yes.
Yeah, and you say that this is where I started, and where I think you really need to address the argument is why is there to be made an implication to prevent the natural effect of that term taking effect, and at what stage and how? What is it that changed? What is I'm balking at is not that you can't have a relation to a contract, not that you can't overlay with Wensbury unreasonableness certain things in the bonanza sense, but what I'm balking at is that you just say, well, lots of things happened and circumstances changed dramatically, and so whoopee, there's an implied umbrella contract which suddenly appears like a genie from the bottle at some unspecified stage. Now, you know, we're a bit more, unfortunately, a bit more nuts and bolts than that here, and we require some foundation for the pleading, but it isn't there, which is why I look so carefully at your pleading. Your pleading just says, whoopee, it all happened because it would be very unfair if it didn't.
Well, it's not quite that, my lord. It looks, the first stage is to look at RCI and who is it. It's wholly owned by Renault. It says it's a financier. It is not. It does provide a credit line in contract 3, but it also provides the platform services, the data services, and effectively is the accounts department of Renault. That's the reality, or at least has come the reality, since the RCI agreements my lord refers to, the 3 have been entered into. So
when was the last one? 2007?
Well, 2008, I think, is...
2008, sorry. Yeah.
Was one at 2010.
Sorry, there was another one in 2010, was it? Might
Yes.
be worth just having...
And there's one at 2012.
Might be just worth looking. Can we just look at the clause in the last one?
Well, the clause that we're talking about here was in 3 and 4. 4 is the last of those 2 in 2012, and that does have the...
Is it in the supplemental bundle?
My lord, yes. So contract 4 is at page 169. That has the credit limit clause in at 3, and it also has the termination provision in the same form as contracts 1 and 3.
And that's 2012.
My lady, yes.
Yeah.
So the credit limit says it'll notify you in its absolute discretion by written notice to the dealer of the credit limit. Right? That's the parts credit limit. Is that right?
No, this is the credit limit for new Nissans, contract 4.
Anyway, they're all in the same form.
Yes, contract 1, 3 and 4, my lord, yes. And then you, for instance, in this context, if you look at in 2014, was at page 209, the clearing agreement. Now, what this does is an agreement between the 3 parties I want to put into the umbrella agreement, i.e. RCI, Nissan, and Mackie Motors. we don't have the same Renault version, but there is one. So what this does is put into contractual nexus the three parties that reflects the reality of my umbrella agreement.
So what does?
The clearing agreement. So it's the only agreement you see in this bundle, and there's another one for Renault we don't have, that allows and recognises under the first recital that each of those parties has contractual obligations with one or more of the others.
Mm-hmm.
And if you look under relevant arrangements on page 210, you'll see that is including the agreement and other arrangements. And there's no termination provision in that. What that does is give some support to the idea of this umbrella agreement, namely putting Nissan or Renault in direct contractual relations with both RCI, I'm calling the accounts department, and Mackie Motors, the dealer. And they found it necessary to do that because that is the reality by 2014 of what was happening.
This agreement is 2014?
My lord, yes. We get that from page 213, the signature block.
So where do you plead that it's this agreement that gives the foundation for the umbrella?
I'd be surprised if you did, because I think the two dates that you gave, my lord, earlier on were 1976 and 1998, not 2014.
2008, I think.
2008, I'm so sorry, yeah.
But I'm not saying it's necessarily the foundation, but it reflects it. Because we put the date before that, as my lady points out.
You've just signed an agreement a couple of years before saying that they can cut off your credit.
So again, my lord?
You've just signed an agreement a few years before saying they can cut off your credit.
My lord, yes.
My lord, sorry, I hesitate to rise. Just one point on the chronology, which is actually the last contract in this sequence is the Dacia addendum, which is June 2013. Now that doesn't replicate all of the terms, but it extends the terms of the finance agreements to Dacia vehicles. And that is...
That does do that.
Yes, that's tab... I don't think it's disputed that it does that, my lord, and that's at tab 14 of the supplemental bundle.
I'm obliged to my friend for that. The clearing services agreement is pleaded at 27, paragraph 27.1.
I'm more than slightly
And,
anxious. I'm sorry. You've just referred to the Dacia agreement at tab.
Sorry, tab 14.
We didn't get a page though.
Sorry, page 205.
June 2013.
Thank you.
And that, you say, reinforces the absolute discretion for credit.
Yes, what I say is that it simply says that the terms that were pre-existing in relation to Nissan and Renault by virtue of the earlier agreement are extended to Dacia vehicles.
Yeah.
I can't say that it sets out the terms afresh, because it doesn't, but it simply extends that which existed before in writing to a new category of vehicle.
And we're on clearing services, so that's also pleaded at paragraph 28 and 29. 29 says the clearing account agreements operate in the wider matrix of the contractual relationship between those various parties. And then the umbrella contract, 30, in the premises. So it's in the premises, including of the clearing account and the services. The dealer agreement is really the foundation of a lot of these points, and the court may have looked at this, but can I refer to a few of its terms, just to hammer home the connection? Two things. is the connection between Renault and RCI.
Sorry, I'm looking at paragraph 30. And this is what you plead as being the agreement. And it's pursuant to which RCI, on behalf of, as agent, provided certain services, right? The services. That's the core obligation. So they were obliged to supply those services. And then you say why it can be inferred in paragraph 32. Is that right? Having said when it was entered into at 31. And you give a whole lot of stuff. And then you say that the terms of that you plead the termination terms. And where do you plead the term of the umbrella agreement? The obligations that they're in breach of under the umbrella agreement?
Para 44, my lord.
44. Contained the umbrella agreement being an implied contract contained implied terms to act cooperatively, to exercise discretion honestly, and not to withhold services capriciously without giving 24 months' notice.
24 months' notice, that's sort of reflecting the term of the dealer agreement. So what it's doing is putting the services, including the finance services in the RCI contract, in the context of the dealer agreement. It's putting them together and saying these cannot legally, contractually be looked at as separate, completely separate.
But that's making sort of quite a few leaps. I mean, it may be one thing to say that the clearing agreement makes it clear that there is a relationship between the three parties together of some kind. And it may be reasonable to infer that what is supplied necessarily for the performance of the other agreements is supplied contractually. But it's a very big step to draw from those two foundations the conclusion that a term in another agreement is to be implied so as to override the ability to give effect to a contractual term in the finance agreement.
Lord, yes, you put it very fairly, but that is what we seek to do. And we seek to do it on the basis of the reality of the relationship, hence the umbrella, is these things are all inextricably linked and have become more so since the RCI finance agreements. So the platform services and the database services and all these other things have come after. And so the relationship has moved on, but the contracts haven't. And so what the umbrella contract seeks to do is to give effect to that relationship. And it uses the dealer agreement as its foundation. It then sees the reality of RCI being the accounts department of Renault. I mean, I say it again, what other finance company do you know that provides platform services, i.e. for the purchase of cars and parts? Or database services in terms of updating people and knowing what HP or PCP contracts are available for customers so they can be contacted towards the end. And in the documents I can show you, it's very clear that RCI is the marketing / accounts function of Renault. So it's not arm's length. The work the umbrella has to do in my submission is relatively small when one looks at the reality. And the reality becomes absolutely clear when you understand, by looking at the obligations in the dealer agreement, how they can only be performed with the services, i.e. the database and platform services, point one, and they can only be performed if the RCI financing that Mackie Motors has a contractual obligation, clause 10, to provide, is provided. So test it in this way. The dealer agreement is for a period of 2 years minimum, i.e. if you terminated on day one, there'd be a 2-year term. In fact, it ran for very much longer. During the whole of that term, Mackie Motors is under contractual obligation to offer RCI Finance Services to its customers. It's also obliged to provide maintenance and parts.
Yes, but when you signed that up, you knew jolly well they weren't obliged to say yes. That was the risk you took.
Well, my lord, that's at the heart of this appeal and this point. Is that so? Because you have a contract with one hand, i.e. the Renault SA hand, the seller of the vehicles, saying 2 years you must use RCI Finance, and the accounts department of Renault, effectively in the form of RCI, that operates the dealer agreement for Renault. That's the effect. It operates it, including finance, but the whole thing.
But there may be a very good reason from their point of view why they put them in separate agreements.
What they seek to do is to ignore the commercial realities. And the question is...
No, there's a very big commercial reality, which is if they don't like you, they can pull the plug.
Well, my lord, that's at the heart of the appeal too, isn't it? Whether the law of contract gives someone in Mackie Motors' position, through dint of a relational contract or some cog from good faith or fair dealing, or through the Braganza duty, in the context of the dealer agreement.
Just tell me, because the Braganza troubles me as a case, what precisely do you say the case of Braganza gives you? In other words, what obligation is to be implied because of Braganza? And just show me Lady Hale's speech that says so.
Well, okay, I'll answer
I
the
read
question.
it this morning, looking for it. I thought, well, okay.
But Braganza itself doesn't, but in terms of, it doesn't go as far as one might think, but in the way it's been interpreted and applied to contractual discretions is, if there's a contractual discretion, then that must be exercised fairly for a proper purpose, a proper contractual purpose is perhaps the best element of that I need to rely on here. It can't be relied on for no purpose or for a bad purpose.
And which is the case that says that? If its case is beyond Braganza. I mean, I remember doing a case where we slightly limited Braganza. I think may even have distinguished it.
Well, if you go to Braganza itself first, just to
Yeah. I noticed nobody had sidelined any part of the dissenting judgment.
I think it's paragraph 18, the sideline bit.
Please, could you give me a page?
Page
Because
110, my lady.
Thank you.
Behind tab 6.
No tabs.
No tabs.
No, we don't have tabs.
So it's the page 110. So contractual terms in which one party of the contract is given the power to exercise discretion or to form an opinion as to relevant facts are extremely common. Not for the courts to rewrite parties of legal bargains, still less to substitute themselves as contractual free decision maker. Nonetheless, the party who is charged with making decisions which affect the rights of both parties to the contract has a clear conflict of interest. Now, pausing there, we say that applies to deciding whether to maintain the existing level of funding under Contract 3. The conflict is heightened when there's a significant balance of power between the contracting parties, as there will often be in an employment contract. The courts have therefore sought to ensure that such contractual powers are not abused. They've done so by implying a term as the manner in which such powers may be exercised, a term which may vary according to the terms of the contract and the context in which the decision-making power is given.
Well, that's a sort of very general bit of introduction. But you get to the nub of the case in paragraph 30, is it? It's clear that unless the court can imply a term that the outcome be objectively reasonable, for example, a reasonable price or a reasonable term, the court will only imply a term that the decision-making process be lawful in the public law sense, that it's made rationally. And that was the decision about whether somebody had committed suicide or gone out on deck for a cigarette.
Well, yes.
And she said, we implied a Wednesbury formulation that if somebody was given an absolute discretion to decide if somebody had gone out for a cigarette or committed suicide, they had to do it on a rational basis. I mean, it was a hard case. I don't say anything about bad law.
Well, yes, and whilst we're in this this area, Braganza, the other sister or bigger brother of this principle is the good faith fair dealing term, which Miss Justice Legacy then was, in fact, is Lord Justice Legate by the time of Sheikh Tarnoon, which we find at page 152, following on from Yang Seng.
Yes.
And we rely on both as candidates for putting a restraint.
So just show me the bit of Tarnoon or whatever the case is called.
It's
call it Kent, shall we?
It's paragraph, page 208, my lord. Page 174 and 175 is the meat of it.
Page 174.
No, page 208, my lord, paragraph 174.
Oh, yes.
So 174, in circumstances the contract made between these parties seems to me to be a classic instance of a relational contract. Application of a good faith in the contract essential to give the parties reasonable expectation satisfies the business necessity test in Marks and Spencer, and then he implies it as implication in the contract in fact, and he also goes so far as implying it as a matter of law based on Liverpool City Council. And in terms of what the obligation involved, para 175, opposite letter F, the usual content of the obligation of good faith is an obligation to act honestly and with fidelity to the bargain, an obligation not to act dishonestly, not to undermine the bargain, entered in, or the substance of the contractual benefit bargained for, an obligation to act reasonably with fair dealing with regard to the interests of the parties. So the bargain here, and that's why it's important for my argument to get contract 3 into the umbrella and or in a nexus with the dealer agreement for this to get off the ground.
You might have read on, Mr. Cavender, because Lord Justice Legate makes the very important point further on at the bottom of the page that the standard of fair dealing or reasonableness in any given case must recognise the nature of the contract or relationship, the different interests of the parties, and the lack of necessity for parties to subordinate their own interests to those of the counterparty. I'm not quite sure how that fits in with your thesis.
Well, my lady, that is always a competing tension when applying this principle, clearly. But if that were to be the guiding principle and shove all in front of it apart, then there'd be no space for the fair dealing term. The idea is it does provide some cog or restraint on behaviour which is contrary to the bargain. But that's why I'm so keen to take you, and I will in a moment if I may, to the dealer agreement and just point out, if you haven't already spotted, very draconian's putting it too high, but considerable obligations undertaken by Mackie, and those obligations being on the contractual basis of funding from RCI.
Well, I think we accept that I accept that anyway, that Mackie has a huge number of obligations, and the objective is to sell zillions of cars in a remote part of Scotland, I think. Is it? It must be a huge area, is it?
Yes, it's up at Arbroath and Brechin. It's in the northeast of Scotland.
I mean, that's very big.
Mm.
Right. Anyway, of course they have lots of obligations. And the dealer has virtually no obligations. And it's all discretionary. But the most important discretion is in the finance agreement that says we can pull the plug anytime we like. Now, how do you override that, even with Lord Justice Legate's broad principle of fair dealing and not undermining the contract, when the contract itself gives the finance arm the opportunity to say you can't have any more money, which you do?
While you're thinking about my lord's question, I mean, I for one would like to know how you can imply a term as part of the good faith dealing which contradicts the express terms of the contract, because I thought that on any view, however broadly you look at Lord Legate's views of obligations of good faith, you can't imply any form of term into a contract which contradicts its express terms.
Well, Milady, yes, I understand that. But one of the points I've made, and perhaps ought to make good, is the fact that these 6 agreements weren't the last word on dealer financing. So I don't know if you go to tab 16, page 215, you go to something called the RCI standards. So these are credit standards that were applied, in fact, by RCI over a long period.
Yes.
And these sit on top of the, I'm taking contract 3 as an example, as to how they were going to treat a Mackie and how the system of funding was going to, in fact, operate. And you'll see RCI expect the dealer to achieve the financial standards below, talking about ratios, and then the dealer expected to achieve at least 2 standards. If the dealer is unable to maintain a standard in future trading, RCI will work with the dealer to create an action plan to achieve the standard within a reasonable time scale. So nothing there about pulling the plug immediately. This is a grading system, which you can see halfway down the page at the bottom, where they're graded to A, B or C, based on the structures at page 216, based on shareholders' equity, working cap and long-term debt. Now that wasn't just a thing written in water, that was applied over a long period, and we see that at tab 17, page 217. What happened was there's a yearly review, a renewal of the facility. So RCI bank authorisation form.
Sorry, if we could just go back. When did the standard become the norm? When was that issued?
Milady, the document isn't dated.
No,
It's
not.
and I'm not sure it's in evidence as to. But for a long time, it wasn't a latecomer. I can't do any more than that.
But is it contractual? Credit scoring and all that?
My lord, in my submission, it is, and particularly when it's then operated for a long period. If we go to page 217, we've got one example. As I say, we were shut out the systems in November. We have this version, which is the 2015 review.
So which page?
Page 217, my lord.
Yeah.
And if you look at in the middle bit, following the head office comments on the March 15 review, this renewal seeks approval of the IFL proposed funding lines, certain action plans for the forthcoming year. And you'll see it's for Nissan.
Well, this looks like an internal bank document.
I'm not sure if that is. My lord, I can see why you say that, because it has a corporate decision at page 219.
Yeah.
Yeah.
But the reason I'm showing you that is more to indicate that this was a system that was operated.
Well, of course they did. I mean, they're a bank, right? So they operate banking procedures. They put it up in the usual way for authorization, no doubt, ultimately to the board if it's a big amount. But
Yes. And
I mean, that's just exercising their discretion. It's just the performance of the term. Why does it indicate that they have to give you credit? It indicates the reverse, doesn't it? It indicates that they'll give you credit if they think you're sound.
But what they do, they seem to do it on a yearly basis. So you have a yearly credit line. You rely on that and do certain things in reliance on it. You order so many cars. You might invest, as we did here. I think we spent £600,000 one year doing out the premises. That's all on the basis of the standards being applied.
But I mean, if you're saying it's like an overdraft, I mean, there's never an implied term in an overdraft agreement that says we can call it make demand any time we want, saying we can't. They can, and they sometimes do. And people squeal. And then they bring all sorts of claims, which no doubt you've seen yourself, Mr. Cavender, when they say, well, you said you wouldn't. And then they make claims that there was a representation that they wouldn't pull the overdraft, and they have.
No, yes.
And they end up here.
But what I'm showing there is other documents that lay on top of the bare agreements in 2008, 2011, as to how...
But you're doing all that to answer my lady's question as to how you can overreach the term of the written agreement with Lord Justice Legate's principle.
Well, what you're trying to do, in my submission, is that these documents, whether contractual or not, would feed the discretion. When you ask, are they behaving fairly or unfairly, in accordance with the bargain, you'd look at the bargain, you'd see how it was operated over a period of time, and that would be the meat of the debate, whether or not the term had been breached or not. If, for instance, you go on and go to tab 19, page 284, you'll see something called dealer rates and terms, which offer to Mackie, pleased to offer you certain terms for finance. The above may be subject to review and change in the next 12 months. And so about total withdrawal, what this is doing is saying you can go out and use these rates on our behalf with our funding. And if you go to page 266, you'll see the various minimum advances and the term. So this is RCI not just giving finance, saying you can use this finance and completely controlling it. So you can do a PCP for 48 months, so a minimum advance of 4.5 and all the rest of it. They're not, it's effectively a credit line rather than, if you like, freestanding finance. Money didn't pass hands. It was just an adjunct to selling a lot of Renault and Nissan cars.
Yeah.
And what you have, say, in the dealer rates and terms is, in my submission, information. And this is contractual. If you look at page 289.
Yeah, that's signed on the 23rd of December
2020, my lady, yes. And if you look at the top of the page, these terms, conditions, do any other terms, including without limitation, the dealer terms and conditions dated 1st of March 2020, well, we don't have those. I don't know what they say or where they are. And they say, I acknowledge receipt about your letter, which is a copy and accept to be bound by its terms. So there is, even in the documents we do have, layers of agreements in relation to finance, which are out with the 6 agreements.
Yeah. And I mean, these are not pleaded as evidence of an overarching implication of good faith. You don't even plead an overarching implication of good faith.
When we do
you
that,
say that you don't do it. I've read paragraph 44 quite carefully as to what you do say. You say you have to exercise a discretion reasonably, and you have to work within the grain of the agreement. Your problem is if the grain of the agreement allows them to pull finance any time.
My Lord, yes, but you can see why I'm taking this, because what my friend's argument is premised on is you just look at contract 3, look at clause 3, and give credit. I'm saying, well, that's part of the story, but there were other contractual documents that over time came to being. We don't have them all, we have some, that were clearly contractual. Look at page 284. And so when you ask the question, is there any meat in the sandwich of the Braganza or of fair dealing good faith? Yes, there is. There are both the conduct and the way the credit was operated and the terms offered does, in the context of the dealer agreement and what was being achieved, does allow the law to have a look at that, there's intelligent argument at least to this, and decide whether that is fair dealing and or is compliant with the Braganza duty. And the reason, my lord, and there is a danger here. I mean, we're not supposed to do a mini trial here in terms of the precise way we plead, for instance, my lord, good faith. The reason it is pleaded in that way because it's aimed at expecting someone's going to rely on the 7-day term, obviously. But there is no defence yet, so we're debating what my learned friend is going to put in his defence, doubtless, and then sort of criticising my pleading for not anticipating that, or at least there's a danger of that.
Well, I think that's a little unfair. What you're being criticised for is not... I mean, we started at the beginning and we still haven't really dealt with that point. What are the circumstances and the communications that give rise to the inevitability of an umbrella contract, which is what you pleaded? At the moment, all we have is lots of things happened, services were provided, and therefore, hey presto, there must be an umbrella agreement. And what I put to you at the start, and my ladies have been putting to you in their own different ways, is that contracts don't really come about like that. They must have some foundation in communication between the parties. They must be absolutely necessary, and even then they must arise at a particular time. And I'm still struggling, really, to see at what point in time the absolute discretion that is contained in clause 3 ceases to be an absolute discretion, and why?
Well, yes, that's a fair question. Now, to answer that, let's row back and ignore the umbrella contract for the purpose of this answer. So we have a situation in which the services are contractually obliged to be provided. That's stage 1. So RCI does have the obligation to provide the database services, the customer financing services, and the platform services. And there are separate contracts which have been entered into in relation to those. That is because they are absolutely necessary and fundamental to the performance of the dealer agreement. That's stage 1. Now that doesn't get Mackie Motors very far, because that doesn't really affect the funding for the purchase of the parts or the cars, which can now be accessed through those services.
And that's the judge's point.
Yes.
Or one of the judge's points.
The
main judge's point.
Indeed. Now, for Mackie Motors to get over that, they need to draw attention to the fact these aren't all separate contracts. The dealer agreement in one part, the 6 RCI contracts in another, a contract for the data services separately, a contract for the platform services separately, a contract for the clearing service separately. That is a tin-eared and uncommercial view of what is going on.
So I mean, I don't really understand that. I mean, I understand it might be uncommercial to you, but it might be very commercial to them, which is why they entered into it.
My Lord, yes,
So
but
how do you, just by saying they look like separate contracts, but they're not, doesn't stop them being separate contracts? They may be interrelated contracts.
well, they're interrelated, and if you go to the dealer agreement, and I will go to it, and if I may, because it's the degree of closeness, interoperability, the fact that they are absolutely necessary for the performance of the dealer agreement. And what RCI is doing is operating the dealer agreement on behalf of itself and on behalf of Renault. It's my accounts department point. It isn't to be seen as a arm's length third-party funder, because it's not. It provides so much more than that. It's a
So
captive.
what? I mean, let's assume you're right. And let's assume that the funder and Renault are really indistinguishable. The funder and Renault has said with Renault XYZ Company 1, we're contracting for 24 days notice, and with Renault XYZ Company 2, we're contracting for withdrawing finance at the drop of a hat, and you signed it.
My lord, yes, but that.
Maybe as interrelated as you like, but
But the question is, does the law have anything to say about that? 24 months, I think, my lord. Means rather 24 days in the first example. In the context where, and I say here the umbrella is a term of art, where they are interconnected in a relational way, long-term agreement, high degree of necessary cooperation. That's what I get from my umbrella agreement. I need that, otherwise I don't get the good faith, fair dealing term. And because of clause 10...
Can you show me a
there's a-
contract? Can you show me one of Lord Justice Leggett, now Lord Leggett's decisions, where the relational term has been used simply to ignore a signed contractual arrangement?
I'm not sure there are any in the bundle. I can give you an example referred to in the extra reasons, is the Bateson Post Office. That was a case where there were post office contracts of both 3 and 6 month notice provisions. The notice provisions said not less than 3 months, not less than 6 months. And the court held that that was a relational contract, and as such, the court could review the operation of that notice provision through the prism of the good faith, fair dealing term, and review whether or not the notice given by the post office was within or out with the operation of that term.
Please, would you provide me with the citation for that?
Lady, I will.
And I think we're going to need more than citations. I think we're going to need to look at it. And this is in the judgment of Mr. Justice Fraser.
My lord, yes. It was referred to...
It's 1,000 pages, I believe. Is it not?
My lord, it's very long, certainly. I was actually involved in the case.
Right, well then you'll be familiar with it. You
Yeah,
can...
exactly. But this was a point we mentioned before.
He overruled. He said you can't give 6 months' notice even though they've signed up to 6 months' notice. Is that
Correct, he did. And the Court of Appeal refused permission to appeal.
Right. Great. Well,
so that's, you know, I accept at the high end of intervention of this term. But we are in an area here where people have different views about.
I'm looking at it now. Do you happen to remember where he said that? Should we look at the conclusions in paragraph 1111?
I don't, unfortunately, have a complete knowledge of where that.
I mean, this is your best case.
Well, yes, and I mentioned it to the judge, and you'll see it's mentioned in the written reasons, the extra reasons for refusal of permission. We can certainly get it over the lunchtime, and I can show you the paragraph. It's relatively short point. But for these persons, all I have to show is an intelligible case that an implied term of this sort can have real effect on express written obligations in contracts. How far that goes, obviously, it's a relatively new principle.
Just where did the judge deal with it in his PTA? I haven't seen that. My fault. And if I can be excused, it's because the electronic bundle doesn't have any proper tabs.
My lord, it's core bundle. If you don't have tabs, well, for those who have tabs, if any, it's tab 7, page 108, paragraph 6.
I'm obliged to my friend. I thought my bundle exploded.
What are the hazards of the trade?
They went away to the bottom there, my lord.
And what did he say? So that's where it's
The top of the next page.
on the next page. He says No.
Even if it was arguable, it's circular, it doesn't help because there's no obligation to provide financing. So what he says is that even if you could use a Bates type term to say you can't terminate the contracts without giving two years' notice, that doesn't help Mackie either, because there's no obligation to provide them with the financing during those 2 years. So that's collapse of stout party on that basis. So it comes back time and time again, doesn't it, to whether or not the relational duty, or however you characterise it, or the Braganza term, obliges them to give you money. That's really what it comes down to.
Lady, that's quite right. But to do so, and let's not forget the Clause 10 obligation from Renault that Mackie Motors have to provide RCI finance during the currency of the dealer agreement.
No, they have to offer
it
to customers, so that then the customer can send in its form saying, I'm a customer with an income of 20 million a year, and the finance company can say, I don't want to finance you because you only got 20 million a year. I only want customers with 40 million a year.
My Lord, that's very fair, but it's premised on the notion that if the customer, a customer meets whatever criteria, lending criteria there are, and it's always done by computer, as you can imagine, that Mackie Motors will have access to the funds from RCI to make good its offering of RCI finance to customers. It's necessarily pregnant with the notion, if you're going to offer it, there's a contractual obligation to offer it, if accepted, then you're going to have the financing in place from RCI to make good the promise.
So does the dealer actually produce the income stream then? The financing doesn't come straight from RCI to the customer, it goes through you?
We have a credit line, so the vehicles are sent.
Yeah, I understand you've got a credit line for your own finance, so that if you're being given help to buy a number of vehicles from Renault on credit, but we're confusing two things, aren't we? I thought we were dealing with the customer's financing, and my understanding certainly was that RCI dealt directly with the customer. So what you do is you offer the finance, and then they get in touch with RCI, and RCI say yes or no and tick the box. But the money doesn't actually get provided via Mackie, as far as I understand it.
No.
Mr. Peters is nodding sagely, so I think I've got it right.
My lady, you have. And so the receivable is received by Mackie, obviously on behalf of RCI. So it is a classic credit line situation.
No, I'm sorry, I
No.
lost you again. Under Clause 10, the dealer has to offer the person on the forecourt who wants to buy that car RCI finance. So
Right.
It says RCI finance is available on excellent terms, and may also even say, here's the website, or here's the information about it, or here's a little booklet, or whatever. The person who wants to purchase the car says, thank you very much, I've got cash in a bag in the back, that's fine. Or they say, oh yes, that would be great, I'll think about it, I might get better terms somewhere else, but thank you for telling me about that. Or they may say, thank you very much, I'm going to take up that offer. They then, it doesn't really matter one way or another, they either allow you on their behalf to contact RCI.
Which is what normally happens. They'll sit down and they'll do the
They'll
forms.
sit down, they'll be in an office,
Yes.
and they'll be talking about whether the car will have the kind of wheel covers and all the rest of it. And they'll also say, can you therefore progress our request for finance with RCI? And the person in the showroom will say, yes, I can do that. And he may do so, therefore, on behalf of as the middleman, in effect, between the purchaser and RCI. Look at the screen, see whatever, and process a request for finance, in the sense of put it on the screen and send it off. But it's the finance then also, I don't know, and this is what I think you said one thing and then I was concerned you said another. The finance then comes back, RCI looks at all the details in the form, is happy that this is somebody they are willing to give credit to, give finance to, and RCI decides that
Yes.
in relation to this person, and then perhaps informs them direct, perhaps informs you, and the money goes from RCI to the customer. And I don't know whether it comes through you or it doesn't, but that I lost track. You were saying that it did. You had a credit line, which is what you were just saying after you'd explained, I thought, that the money came from RCI to the customer. You then mentioned a credit line, which suggested that you had a sort of bubble of money from RCI that then you fed down to the customer, and I don't think that's right, is it?
No, the customer doesn't get the money.
No.
No. Well, we receive.
Gets the finance.
Gets the benefit of the finance.
Yeah.
And providing the customer is creditworthy, as your lady says, and it's within the Mackie credit line, then the sale will be authorised on the PCP or the HP terms. There's an assignment agreement, which we don't have a copy of, between Renault and RCI, which is the detail of how it works between them, which we don't know precisely. But what we do know is that Mackie Motors receives the receivable and passes it on to RCI.
Receives the receivable. What do you mean by that?
Well, the payments.
Okay.
That can't be right.
That's
Sorry, that
That's
makes
why I'm- that's
absolutely
why I'm-
no business sense whatsoever.
that's why why I stopped.
It's not how hire purchase works, for a start. I can see that you might be treated as being credited with a full payment. And there might be some accounting going on, but it just doesn't work that way. It can't work that way.
It was the use of
If
receivable.
I can,
that
if I can
didn't
assist the court,
understand.
although tell me if I'm not, my understanding is that RCI buys the vehicle
Yes.
either from Mackie, if it's a vehicle owned by Mackie, or from Renault, if it's a new vehicle still owned by Renault.
Yeah.
And then owns the car throughout the term of the hire purchase agreement or whatever. And the customer has a contract with RCI
and pays RCI off.
and
Yes.
pays RCI off, either in full over the term of the agreement or subject to balloon payments
Yeah.
or whatever. And that is how it works. So actually, to the extent that money is going anywhere, money is going from RCI to Mackie if the vehicles are being bought from
It's a
Mackie.
second-hand vehicle.
Yes, exactly. But in a new vehicle, not necessarily. But there's no circumstance in which that could give rise to a facility in favour of Mackie.
Yes, I'm grateful for my info. I was confusing the two stages.
And therefore, the receivable that you were talking about, which is when I stopped because I didn't understand, it is because, for example, RCI accepts the customer as someone they're willing to give finance to, and as a result, pays you, if it's a used car, for the vehicle.
Yes.
And that's the receivable you were talking about.
Yes, if it's a used
Okay.
car, yes. I was
Yeah.
confusing the two.
Yeah.
Yeah, I'm obliged. So, but the reason this matters is because there's a direct connection in my argument between RCI funding, put it that way, and the financing of these vehicles and parts, same point applies, and the 6 contracts. And the question is whether the long-term nature of both the dealer agreement and all these arrangements are sufficient to sustain an umbrella agreement into which I can imply my term of fair dealing or braganza. That really is the issue.
Say that again then. It's really the issue.
That having regard to the long-term nature of the dealer agreement and its operations through that and through the capital S services, which involves, in the definition of the pleading, the dealer finance, the customer finance, the clearing services, the database services, and the platform services, when looked at as a whole, commercially, that reflects a long-term relational contract, which is a term of art. An umbrella is established incorporating those contracts under its umbrella, and into that is implied the term of good faith and fair dealing. Without that umbrella or implied term of fair dealing. You're trying to imply that term into each of those individual contracts and ignore the fact they are necessary for the interoperability of the whole.
And I tell you what's bothering me, and that was a much longer way of stating the very simple issue than you started with when I stopped you. But anyway, what's bothering me is that even if you're right about all that, how could commercially there be a term that prevented RCI saying, I'm not giving you any more money because I don't like your customers, or because their income is too low, or because I'm just fed up with giving you money.
Well, my lord, that they could do.
When the arrangement between a bank and a borrower and a finance company and a dealer or a lender or a customer is always on the basis that they look at proposals individually for lending money to individuals and decide yes or no, and they can always say no, and the relational bit doesn't really overbear that. And if it did, a lot of finance companies would probably have a heart attack.
Well, my lord, I think the answer to the question is RCI is not a finance company in that model. It's gone way further and become the Renault financing arm and the accounts department, really, of Renault. Now, finance companies don't do that. They don't provide platform services. They don't provide data services. If, for instance, you look at another document you've not seen in relation to how these things work. And
they really use, I mean, you sort of go as far as saying, not that it's dishonest, I'm sorry, I'll let you show me that document in a minute, but you sort of say not that it's dishonest, but it's a false characterization to say that RCI and Renault is in any way separate.
Correct. I say it's all to you go. We sort of.
And they're all the same, and this is not a financing arrangement, and therefore having the separate finance agreement with clause 3 is a fiction.
Effectively.
Sham.
Well, sham is difficult because that does suggest fraud somehow. But what it doesn't reflect the real agreement between the parties.
Well, there is a problem there if you shun the term sham, because sham is simply an agreement, I believe. I mean, I've forgotten Lord Diplog's classic definition precisely, but I think it's an agreement between the parties that they will put something down in writing which doesn't reflect the real agreement. And that's what you're saying, as between anyway Renault and FCI.
Well, certainly insofar as it suggested that RCI were a finance company, as the judge held, a bit like an ISDA agreement with all that goes with that. That's what's said against me, and against that I do have no answer. But my case must depend upon RCI and its relationship in relation to this financing in this agreement, and that was tied hand and foot, is that it wasn't just a finance company, it was the way that Renault ran its dealership. And that point can be made good by looking behind tab 20 and this document at page 290 called Renault Route to Market. To give you an example.
Which page?
It's page 290, my lord, in the supplementary bundle. So this is ostensibly a Renault document. You see at page 293 a message from the Renault managing director. And although it's a Renault document and you think it would be talking about cars, it also talks about finance and RCI and what RCI are going to do. For instance, if one goes to page 298, Renault Finance Renewal Customers. This is a Renault document. Our existing customers mean a lot to us, so returning customers will receive $7.50 additional retail loyalty support through Fisk eMaster. Pausing there, Fisk eMaster is one of the database services. So to get that, you have to have the database services. And what you have on this page is what you'd expect. you get loyalty supports, and you get deposit supports, as I'll go to in a moment. If we go to the right-hand side, yeah, the top right-hand corner, you'll see Renault Finance RCI action. Make sure robust renewal in focus in your dealership on retail. Work with your RCI account manager to plan the best contact strategy on achieving your financial renewal objective. Guide customers through their end contract options using the account review process. So this is a Renault document, and what you see is RCI being put forward as part of that to provide exactly what you expect the accounts department of Renault to be doing. And then if you look below that, all new
Why would the accounts
PC.
department of Renault be providing finance?
Sorry, my lady.
Why would the accounts department of Renault be providing special financial terms for customers?
Well, it would. Okay, not providing it. It would be managing it and involved in its promotion
So
and.
the administrative side of the.
But it's not just administrative money. That's the point I'm making. It's not merely administering finance. The platform services, for instance, is the where you buy cars and parts and service and all the rest of it. It is the operation of the dealer agreement. Put it another way.
So that's more than an accounts department, isn't it? It's not a. It's a different sort of arm.
Well, account / operational. It basically ran the whole show, my lady. If you ask the question, what was the contact between Mackie Motors and Renault in the operation of this agreement? The answer is none, because it was all through RCI. RCI was running the dealer agreement, in effect, the finance side, the accounting side, the whole operation. And when looked at like that, where in reality that's the position, to have that party together with Renault, on the one hand saying it's 24 a month's notice, on the other hand saying we can take our bat and ball and walk away without notice, without reason, any day we like, is, in my submission, surprising. And the law of contract, in my submission, does have ways of restraining that.
Well, also we need commercial certainty. And, commercial people need to be bound by the contracts they make, which is why we have such strict rules for the implication of terms. And we have even stricter rules for the implication of terms that overhaul express terms. Right. Now, I completely understand that Bates was a very, very special case. But you haven't even shown us Bates. Are there any other examples of cases where, in this context, the context of formal arrangements, I mean, there must be millions of dealerships and supply agreements for not just cars, but everything else, engineering products and goodness knows what else. Is there any other example where an express term agreed in the financing context is overhauled by a whole series of stuff which happened?
Well, my lord, I'm not quite sure it's fair to say stuff that happened, but in
Well,
answer
I mean, reality, because people do set out commercial relationships in very particular historical ways, and car dealerships are, this is absolutely standard as far as I can see. This is the way it's done. So the stuff that happened has to be quite strong. Now, you say it is, I get all that, but what I'm looking for is a case where, as stark as Bates, in the context of commercial arrangements. I mean, Bates was a very hard case, right? And you can completely see how the judge reached the conclusion he did. But it's a first instance decision which doesn't bind us. What I'm looking for is cases where, in a financial arrangement, a financier has been effectively forced to supply finance against its will.
My Lord,
and against the contractual term.
My Lord, I don't know of any. Obviously,
So this is a very important first case.
well, it is as to the meaning and extent of the fair dealing term. Its reach.
Yes, I mean, I don't think every contract has a fair dealing term.
No,
I
and that's
mean, I
why
don't
the
think-
umbrella contract and the long termness, I have to keep pressing.
Yeah.
It's only in that situation that I have a chance of persuading anybody that it's a relational contract into which it's capable of implying a term, whether by fact or in law. And the question...
Why is that? Just help me with that. Why can't you imply good faith on the grounds? Let's assume in your favour that the clearing agreement or whatever it's called between Renault, RCI, and Mackie, which are the parties you want, that's a contract. Why do you say you couldn't persuade anybody ever that there was an implied term of fair dealing in that?
Because there's no legal precedent for doing it outside. It's hard enough doing it in a joint venture agreement. You'd have a very hard time, but the Bates and the Lord Justice Legate development, people have different reactions to it. There haven't been that many cases that determine.
He's never given a judgment in the Supreme Court to that
He
effect.
hasn't, my lord, no. Everyone's
Only
waiting
a
for a
matter of
case.
time.
Case when he
Not
does.
yet.
And my lord's quite right to identify that there are more than two, but we're talking about two potential circumstances where the term can apply. One is to what appear to absolute or quasi-absolute rights to terminate, Bates as an example. And another is where you've got an extant situation of the provision of finance, as we do here, and a term that says you can reduce it to nil at the drop
I mean,
of a hat.
presumably what Bates says, and I haven't read the whole thing, although people keep on giving me bits of it. Presumably what Bates says is that you must exercise in good faith the power to terminate.
Correct.
And if your computer system is completely dysfunctional,
Yeah.
and you do nothing to make sure that it's working, you can't just terminate
Dismissed for that
everybody.
reason.
Yep.
You can't then, the argument
Exactly.
goes,
You
dismissed for
can't
that reason.
just terminate everybody on the basis of a dysfunctional computer system because it's not fair, which, I mean, one completely gets. But it is a different thing, as you, I think you're acknowledging, where you have a financing arrangement, even if it's Renault that is the financier for this purpose, let's assume. You still have to, I mean, what the key thing that you identify as what they can't stop doing is lending money when you offer finance under clause 10, because that stops your business.
Correct.
Anything else doesn't completely stop your business. The parts stuff is a nuisance. But anyway, initially it wouldn't completely stop your business.
Well, the other things law do stop the business. So that's when they shut us to the chronology. On the 27th, they shut us out of the database and the platform.
With the database being their database of what cars are available. So somebody comes and says, I want a red Renault Megane.
And you can't sell it. And
you can't sell it because you don't know if there is one.
No, exactly. So it does that. That's why those are essential. That isn't nice to have and makes it difficult. You just, as the evidence.
But I get they're essential. But I think when you cut to the chase, even you accept that only gets you so far.
Correct.
Yeah.
Absolutely. And why I need the umbrella, which is a term of art, and you saying, well, when does it arise? I mean, it arises once you identify a stage at which you're moving from the old school finance type model to one where RCI is taken over, really, provides all these services in the modern world.
Why does it matter? I mean, just help me with this. Why does it matter that RCI and Renault are indistinguishable? I mean, all big companies and finance, banks, everybody operates with subsidiaries doing slightly different things, which are indistinguishable. I mean, some of them have offshore arms that do bits of stuff for tax reasons. I mean, which, provided it's not illegal, is not improper. It's right to say that X bank Cayman is the same as X Bank London, but it, unless they're doing something illegal, it's not prima facie illegal.
No.
So let's assume in your favour that RCI and Renault are exactly the same entity, just with different subsidiary names.
Yes.
Why does that help you?
Because one of those two parties or parts of the whole has undertaken contractual obligations to Mackie Motors of a long-term nature with a 24.
But the other hasn't.
But the other hasn't. But in the context of the closeness and necessity for all the services and the financing, the court, and this is really the construction argument, really, that I ran, and the judge said he thought there was something in it, possibly, but it didn't really help me because of this point about being able to reduce the finance to zero.
But that's the whole point. I mean, if I say to you, I am X Bank, big bank, let's not use names. I'm a big bank, and I'm going to contract with you to sell you cars through this company, and I'm going to give you finance through that company. You know all that completely. You know we're all related. And I'm not obliged under the second agreement to give you finance, and you also know when you sign up that if you don't get finance, your business stops. Now, what I struggle with is why does it make any difference that I've said the first agreement has a 24-month notice clause and the second agreement has a 2-minute notice?
Well, it matters because that would give greater grounds for saying that you must read one as subject to the other as a matter of commercial necessity. If you, in terms of interpreting what appear to be conflicting obligations.
I mean, the problem with that, the figures are 90%, aren't they? 90% of
Yes.
cars are sold on finance.
Yes.
I mean, if that's the case, then obviously if you can't sell a car in finance, you can't sell a car. So you know throughout your relationship with them that you're on that part of your relationship is a sticky wicket.
But not just sticky, my lord. If you look at that question through the prism of say, the yearly ordering requirement, it means you could be stuffed with RCI finance in year one, year two, when you're about to reset the yearly ordering. They look at, one of the things in the contract is the past sales. You then have a contractual obligation to say buy from them, let's say 500 cars.
But they haven't presumably enforced that obligation.
Well, no, but I'm looking at this in terms of the contracts in order to test the commerciality of my point about reading.
So you say they could now enforce that you buy 500 cars you can't sell?
Yeah, and as a deeming provision, I buy them.
So what would be your defence to that?
I wouldn't have one unless I could read down the.
I think you might have one. Might you not have one that they'd effectively stopped you dealing in cars?
Yes, I mean, I suppose the implied term not to do anything to undermine the basis.
I mean, it would be, well...
An interesting case. But the reason...
Not that interesting, I don't think.
But the reason I put it forward, I'm trying to test the contractual terms.
That might well be a case for an estoppel, genuine estoppel.
That would be might be a genuine estoppel. I mean, just summarise, because we haven't got unlimited time. I mean, your submissions have been very helpful, Mr. Cavendish, if I can say so, because they have been very frank with us about the hurdles in your case, which is a really helpful way to have done it. Just summarise how you get over this, what I think all three members of the court at the moment find the most difficult part of the case, which is to get over the written obligation in clause 3, even if Renault is part of the arrangement and we get over the technical bit. So you've got some agency, Renault operating through RCI, or RCI operating Renault as part of the dealership. What are the factors that make it inevitable that in the terms of Heiss and Modal, not cases we've looked at, but you may be clear that we understand what those cases say, in those terms, why do we get as far as implying a contract?
My lord, with respect, I think implying a contract is relatively easy.
Well, implying the contract,
Implying the umbrella contract with
Yeah.
the good faith. That's the difficulty. It's the second step, I think, is the difficulty. And the way we meet that is by firstly saying that, which may be conceded in the question, that RCI here is not a capital F finance company. It is the operations accounts department of Renault. That entity, Renault, has entered into a dealer agreement with certain obligations in it, most notably a 24-month notice period, and other minimum obligations for purchase and other things that place on Mackie an obligation for a period of 2 years to supply RCI financing and Renault parts funded by that and maintenance. Given that is so, and given this is a long-term relationship of where there needs to be a high degree of cooperation between the parties, which is one of the main incidents of a relational contract, it's necessary to imply in the terms of HICE the umbrella agreement, i.e. to recognise, it's necessary to recognise, to give those relationships commercial reflection, this umbrella agreement. And all that is doing is aping the clearing agreement, which was an express agreement entered into, which itself reflected the reality, certainly by 2014. And if that is right, then, as the judge said, that if there was such an agreement, he would have no difficulty in saying it was relational. And if it's relational, based on Yang Seng and the Ao Kung and other cases, whether by way of implication by fact or implication of law, there is a fair dealing term. The question then becomes, how does that operate on either, we've not really concentrated on the 7-day notice term, but clause 3, the ability to remove credit. Now I say you then look at how the credit was operated, including the ICI standards and the review, and how that was operated, and if there were any problems with the view of RCI with the creditworthiness of Mackie Motors, they would be dealt with over a reasonable period using the words of the ICI standards, and they wouldn't just resort for no reason or a bad reason to remove the credit altogether.
So you're saying that it would work, the good faith in relation to clause 3 would work in the same terms as the framework that you see in the standards document.
Exactly.
And therefore you're focusing in that respect on the credit, the flow of monies, although they're not necessarily changing hands, which enables you to run the business rather than the side that we were looking at before, which is the man who wants to buy the car on forecourt.
Exactly.
It's what enables you to purchase the parts and used cars, etc.
Yes.
And you would say, I suppose, that they were obliged simply to, in a Braganza way, to operate the discretion to provide finance in the way they always had, so that if somebody turned up with an income of 20,000 a year, they could get finance to buy a small car. They wouldn't say, we've just decided today that you've got to have an income of £20 million to buy a small car.
No.
So they would just operate their discretion in an entirely consistent and normal way, and that's what Braganza says. You've got an absolute discretion, you've got to operate it rationally and reasonably.
And in accordance with the standards and the way you had done for the last period of years.
Can you just help me with you had a credit line for Mackie, right? That's not clause 3, is it? Did they withdraw the credit line for Mackie? Your own credit line for holding a pool of, no doubt, demonstrators and that kind of stuff?
Everything was withdrawn, which is clause 3. Everything.
Oh,
was
clause
withdrawn.
3 is deals with customer finance as well as Mackie finance. No.
Not expressly, I don't think. But the answer is everything was withdrawn. So all credit, all financing offers, platform services, database services, everything. So that's why Mackie had to perform a fire sale, because otherwise, this is another contractual point, he'd obviously sold a load of vehicles to people who were able to pick them up the next day and the next week.
Yeah.
Which he didn't necessarily have and couldn't take delivery of because of the platform and other services. So he was potentially be put in breach of contract in relation to all those things, including some that had been...
So they sold in a few days, did they, over the weekend?
The business...
They sold the business.
Well, it was very quickly. It was over the weekend. It was certainly a number of days, my lord. So all these contractual problems didn't happen.
And then Renault just quietly entered into a new agreement with the vendor,
yes.
the purchaser. Right.
And so all these contractual difficulties, which would illustrate my point, didn't actually happen. Because you'd have these people saying, I've bought a contract from you, Mackie Motors, I've paid you a deposit, I've maybe got even a trade-in price. Where's my car?
And I suppose you say you don't have to meet a very high hurdle for this.
No. But that's the net effect of my learned friend's submissions. That's all fine, and that's all. That's what you signed. That's the effect of what you signed.
So Braganza. So you say they can't use clause 3 to bring down the House of Cards because of Braganza, because they're obliged to offer finance on normal terms.
Correct. And if you could
Not
withdraw
quite
it,
what you did say, but I can see you might say.
but for normal and for normal credit purposes, that's what it's there for.
Okay.
Which is another way of looking at the fair dealing term, which is you operate a contractual term in accordance with the bargain for its proper purposes, and the bargain here is for the sale of these cars.
And any other result, Mr. Cavender, you say in your skeleton twice, is shocking.
Well, but perhaps I'm naive, my lord.
It doesn't help to use those words. Is there anything else you
My lord,
want to
unless
say?
I can assist further, I think those are my submissions. Thank you very much.
Thank you very much, Mr. Cavender. We'll just rise for a couple of minutes.
All right. Twice.
Yes, Mr. Peters.
My lord, my ladies, I want to start, before getting into the detail of my submissions, with some general points that arise out of the discussion that you've had with my learned friend. The first point I want to make is that an awful lot, arguably most of his submissions, boil down to the proposition that the agreements as written leave Mackie in a commercially vulnerable position. And they do. The second proposition, which must be part of his argument, although it's not stated, is that that's something that this court should be astute to do something about. And we say that is just a false point, because to the extent that the agreements give rise to a relationship that is vulnerable and therefore disadvantageous to Mackie, by the same token, they give rise to a relationship that is flexible and therefore advantageous to my clients and to Renault. Doubtless, as a reflection of their relative bargaining power, the parties have entered into contracts with benefits and burdens that sit in a particular equilibrium, or lack of equilibrium. But my short answer to that is, so what? That's what the parties agreed to. My lord, the second general point I want to make, and it's easy to get lost given the way this was being developed in my learned friend's submissions, is that RCI and Renault are different companies. They work together. They are clearly connected companies. But there is no basis for piercing the corporate veil between them or treating them as if they were one company. And there has been no suggestion, either in the pleading or in argument, that that is something that the court should do. And it's something that the court would only ever do in certain very limited circumstances. And on Supreme Court authority could never be done so as to bind Company A into Company B's contract. And the next proposition that flows from that is that here we have contracts such as the dealership agreements, to which Renault and Nissan are party, and RCI isn't. And we have other contracts, in particular what we've called the written contracts, the finance agreements between RCI and Mackie, to which RCI is party, and Renault and Nissan aren't. And that is important when one is having arguments about the extent to which the contracts compendiously are or aren't capable of performance in accordance with their express terms. So taking a very simple point, the finance contracts are perfectly capable of being performed in accordance with their express terms without any need for implication or outlandish construction or anything of that ilk. They're very simple agreements. They provide for money to be handed over by particular means and for it to be paid back in certain circumstances with given rates of interest, subject to overall, in effect, facility limits. What is really being said by my learned friend is that the dealership agreement can't be operated in accordance with its terms unless Mackie has access to certain things. Now, my lord, my ladies, you can see how that might be the beginning of an argument that terms should be implied into the dealership agreement to give commercial efficacy to that agreement. But there are two problems with that. First of all, that's not the case pleaded in the draft amended particulars of claim. That is not the case that my learned friend was or is seeking permission to advance. So the fact that it might be theoretically possible is interesting but irrelevant. And I was going to deal with a procedural point, and I am going to deal with that, my lord. The second point, which is important from my client's perspective, is that my client would not be a defendant to that claim.
You just represent RCI.
I just represent RCI. So, on any view, I mean, assume that that case were allowed to be pleaded, could be pleaded. RCI wouldn't be a defendant to it, unless
Yeah, I regret to say that I think you might find you would be, but
Probably find yourself third party.
yeah.
Well,
but
but my point is, it's
your
not.
point
a
is
claim.
you wouldn't be the primary defendant.
We wouldn't be the primary defendant. And actually, if the logic were that Renault was obliged to bring about a result, actually, I mean, obviously, it's difficult to see how these things
But
play
I mean,
out.
obviously, Mr. Cavender would say that if we'd gone that far with him, what on earth are we doing, striking the claim out rather than letting him join in Renault and amend the claim in all sorts of different ways? And
Well, this is
not
where I was
waste
going.
not waste a bucket of costs.
Well, this is where I was going to come to this procedural point, my lord, which is imagine that such a case could be made. What to do about it? And there, I'm afraid, my learned friend's got a real problem, because there are cases. It's not uncommonly the case in an amendment situation that a party recognises that perhaps its amendment is in trouble, and so it bargains with the court. It comes up with alternative arguments, and there's a sort of back and forth.
We don't do bargaining here.
Well, the court may not, but certainly counsel frequently
Counsel may
attempt it.
try it. Yes.
But, my lord, the point is this. In some ways, to their credit, the claimant has never run the case that way. The case before the judge wasn't the draft amended particulars of claim, or if we get into trouble, some other variant of it. They nailed their colours to the mast. It's that or bust. And the question for this court, in my submission, is whether the judge was right to refuse permission to amend on the document before him. And I can test it this way, my lord. Imagine that Lord Justice Nugent, rather grudgingly giving permission to appeal, had not given permission to appeal at all. And then Mr. Cavender had popped up 3 weeks later and said, I've had a brainwave. We should do this claim a different way. And so I want to apply to set aside the judge's order and reinstate the action. And bear in mind, it's a final order. It's an order dismissing the proceedings.
Well, you just issue a fresh claim form against Renault. Or is he out of time?
And then, no, I don't think there would be a timing position. And obviously, I can't speak for what Renault would say. But Renault might say that gave rise to abuse of process issues in circumstances where you had your crack at RCI and Renault. My point is, coming back to court and saying, I want another go because I've thought of a better way of putting my case, is not something that entitles you to have another go.
I mean, you've laid down that marker.
Yes.
And for my own part, I completely understand why, if there were new proceedings, you might want to make a big fuss. Could you help us with the more fundamental arguments to this case, which is why I think really the question comes down to why there is not, it was the summary we got right at the end, why there is not an implied obligation in this long-term relationship, long-term dealership relationship, that you will not pull contractual services like the website and all that overnight, and why, when it comes to clause 3, there is not a Braganza obligation to grant finance according to normal principles rather than just pulling it overnight in the context of the entirety of the long-term relationship between Renault, RCI and MM, and in the context of the clearing agreement, which makes that clear.
Well, I'll obviously deal with matters in the way the court's going to find most helpful. But the reason I pause is there's a question of what case am I meeting here? Because the way the case has been structured, by reference to the different grounds, I
put it quite carefully to you,
yes,
on the basis that that is really his umbrella agreement.
Well,
I didn't put it in the way you started meeting it, which is that it's just an implied term, might be an implied term as well, of the dealer agreement. That might meet the problem you identified. But he says, and he has to be hoist with this in opening his appeal. Sorry to call you he, Mr. Cavender, but it's best you get. He says, I need an umbrella agreement if I'm going to get home, because otherwise I don't get Braganza and I don't get Lord Leggett.
Well, I see that, my lord, and that's why I had those introductory remarks, because they arose out of the discussion. But what I was then going to do was deal with the grounds as they arise. So the first ground is there an arguable case that the umbrella agreement exists at all? Because that's what drives all of that. The way it's been pleaded is this whole Braganza implied term, it all comes via the umbrella agreement. And as your lordship rightly points out, it's been said by Mr. Cavender that it has to come in that way. But before you get to any issue of Braganza-type implied terms, there's a more prosaic issue, which is, has the umbrella contract been formed? Or is there an arguable case that the umbrella contract has been formed? And I was proposing to deal with that on the nose, as it were. So...
Well, you say, and I mean, I wouldn't want you to spend too long on this, you say there's no pleading of that.
Well, what I say is that there's a pleading of it in the sense that it is asserted.
Yes, but it's asserted it came into force not later than 2008.
Yes, and what I was going to say, so I was going to make a, well, again, it depends how the court wants me to proceed, but I was actually going to look, I think, briefly at the law, because I suspect the court has the legal principles well in mind.
We might need to see them.
But I was going to do that, and then I was going to go through the pleading to see what's actually said, and how, if at all, it is said to be consistent with the existence of an implied contract, which is what we are talking about here. The punchline...
The problem, I mean, the punchline, the thing that, anyway, to a certain extent impresses me, is that I can see that the services that are made over time absolutely imperative for the performance of all the agreements could have become contractual in some way. Now, I don't know if you accept that.
Well, can I think actually one needs to strand it out more than that, my lord, because this terminology of the services has been used.
Well, I meant the things like, you cannot sell a car without access to the database.
Well, that's exactly what I thought your lordship meant. Yeah. What I was going to do
I didn't mean all the bells and whistles.
No. What I was going to do is break it down. I was going to deal with it later, but actually it probably makes sense to deal with it now, which is the services and what they are and how they fit together. Because what you have is what have been called the dealer financing services. That is a line of credit to the dealer, to Mackie, to buy used cars, new cars, and car parts.
Yeah.
In effect, to enable it to stock itself so that it can operate as a car dealer. Those services are subject of what we call the written contracts, but the 6 express written contracts between RCI and Mackie, some of which you've been referred to. The second strand of financing is what has been called the customer financing services, and you've already had a detailed explanation of what those are and how they work.
Yeah.
And it is common ground that there is no written agreement between RCI and Mackie that governs whether and how that form of financing is to be made available to Mackie's customers. Of course, it's never a type of financing that is made available to Mackie itself, by definition.
Yeah.
So the only basis on which there is said to be any contractual obligation to provide those services is the umbrella contract. Then we have
clause 3.
This is not within. Clause 3 is the provision in the dealer financing agreement.
That's one. That's the first of them.
That's
It's
only
the credit
dealer
line.
financing.
Yes.
I thought it covered everything, Mr. McCammonder told me.
It doesn't. We can go to it, but it doesn't.
It doesn't.
And I thought, actually, it was common ground that it doesn't. It's
Okay.
never been suggested that those
No,
written contracts...
I don't think it matters for this purpose.
No.
Keep going.
Sorry, did my lady have a...
No, that's fine. I've got it.
Then you have a constellation of services of an essentially administrative character. And I call them administrative not to denigrate their importance, but simply to accurately describe them. Things like the website, the database.
Well, those are important, aren't they?
They are important. But what I say is this, which is, I mean, what is said is, well, look, if you deny me access to this, I can't buy stock, I can't order parts. To which our response is, yes, that's serious, undeniably. But if we're allowed to cut off your financing, if we're allowed to cut off the money that you were going to use to buy stock and parts, then being able to access the systems through which you place orders, not very helpful. Because you can say we had cut off the finance but kept open the various online systems through which the relationship is managed, well, Mackie would continue to be able to access those systems but wouldn't be able to do anything.
Well, that's the judge's point about the financial point being really at the nub of all of this.
Yes.
But I suppose Mr. Cavender might say, well, if you're looking for an overarching agreement, an umbrella agreement with allied duties, then the dependency or the interdependency of the dealership upon the services that you're providing is important, irrespective of what might happen if you cut them off.
Well, I think that is... So the point arises in different places, I accept, my lady. So I accept that it is said that the fact that there is a relationship of dependency in a general sense, because it is said that Mackie is dependent on RCI in multiple different dimensions, that is said to be, in a general sense, relevant to the existence of the umbrella agreement. And I propose to deal with that when I go through in more detail how this agreement is said to have been formed and whether that case is cogent or even comprehensible.
So you were answering my question when I took you out of your preferred course. And we're getting towards 1 o'clock. But I think you accept that it is possible that you were obliged contractually in some way at some stage to provide them with a website and a database so that they could perform their obligations under the written agreements.
I don't accept that. And I don't accept that because I say that that can only arise under the umbrella contract, and for various reasons that I haven't yet developed, we say that there...
So you say there was no such contractual obligation on anybody.
But can I a point I was going to make later, but it's perhaps worth making now, is I've given you one example, which is imagine there's no obligation to provide finance and we can pull the plug. Then all of these ancillary services, important though they are, don't amount to a hill of beans because...
Yeah, but they don't matter, but that doesn't mean they're not contractual.
No, I suppose I'm sort of making the opposite point to Mr. Cavender to that extent. Yes. But what I was going to say is imagine a different scenario in which we are obliged to provide finance and we cut off access to these various services.
Yeah.
Now, actually there, one doesn't need a contractual obligation. What Mackie could say in those circumstances is, look, you've agreed to provide finance for support to this business, and you, Renault, have entered into a dealership agreement. You have chosen to put in place this non-contractual infrastructure. Fair enough, that's your matter. But what you can't do, but you don't have any contractual right to insist on the use of that infrastructure, and if you choose to pull it, then you still have to make the agreements work by some other means. That, I suppose the simple way of putting it is that the non-contractual nature of these ancillary services is necessarily symmetrical, in that if it's not a contractual matter, they don't have the right to insist that we use those, that they be given access to those systems, but we don't have the right to insist that it is only via those systems that the contract be performed.
That's all well and good, Mr. Peters, but we've got to look at the commercial reality here. Without access to those systems, they're not going to be able to stock the new cars for a start, because they've got to get them from Renault from somewhere. and they're not necessarily going to get access to the parts, but more importantly, they're not going to be able to offer their customers the special deals which are being used as financial imperatives to the, or incentives rather, to the dealers to be able to go out and sell more cars. So there is an air of unreality about that submission.
My lady, I'm not sure I accept that, because this whole argument proceeds, I'm testing a hypothesis here by reference to there being obligations to provide the dealer financing services and the customer financing services. So the answer would be, look, you Renault, or you Mackie, you have to provide us with access to those substantive services. And what you can't do is effectively block our access to the services that you are obliged to provide via the medium of this online system. But my point is, access to the online system itself doesn't need to be contractual at that point, because their complaint doesn't need to be, you've breached the contract, a contract to give me access to those systems. It's by denying me access to those systems, you've breached the more fundamental obligation.
To provide the finance.
To provide the finance. That's the point. And that's why we say, I mean, it always, this can often arise. The parties enter into a contractually binding agreement by which they have obligations that need to be managed. As a matter of choice, they use a particular system to intermediate that. The system itself doesn't need to be contractual. And being non-contractual, it can't be relied upon by either party to defeat the underlying substantive obligations.
Well, it may not need to be contractual, but that begs the question as to whether it was.
Yes, although the question of whether it needs to be and whether it was are not wholly separate questions when one is talking about the implication of a contract. So there is a... And perhaps that, I was going to say, that would be...
Let's come back to that at 2 o'clock, please.
All right. Well, I don't know if you want the reference to Bates. Does my lord want the reference to Bates?
I've got the reference to Bates.
Yeah.
I expect my ladies would like a copy of it.
I'll get it over.
And yes, thank you.